Well, good morning to all of you. First, I would like to take the opportunity to thank the organizers, Professor Vreemuth. This is really a marvelous conference. The quality of the introduction is high. Lovely people, good food, and an enchanting environment. You walk in a fairy tale. So I have seen a slogan on the wall. Wir bauen nicht ewig, aber für die Ewigkeit. Now that's a great consolation, I would say. So without much ado, I feel very happy here, and I see a lot of new people, and I see a lot of old friends, and that's of course very nice. The title of my presentation is Different Standards on the Prosecution and Trial of Syrian Political and Military Figureheads and Foreign Terrorist Fighters. Now, there will be some overlap, I guess, but that's not such a big deal. We are here to discuss at length all very interesting issues. So without much ado, I would like to start with my presentation. Last February, the Koblenz Higher Regional Court, Professor Bock already referred to this, convicted Ayat A to 4.5 years imprisonment on account of aiding and abetting in torture as a crime against humanity. Procedures against his boss, Anwar R., who was the head of the investigation section of the notorious branch 251, are still running, but the verdict is expected this fall, if I'm not mistaken. Is that correct? Yes. These criminal procedures on the basis of universal jurisdiction have been the result of the tireless efforts of NGOs like ECCHR and Open Society Justice Initiative. That these persons have been involved in crimes against humanity is, if the facts are proven, of course, uncontroversial. The Syrian regime has engaged in torture of political opponents on a widespread and systematic scale. So we are getting somewhere. However, it's the tip of the iceberg. If I'm well informed, plaintiffs have made similar submissions in Norway, Sweden, and Austria. While these cases are under investigation, they have not yielded court judgments as far as I know. Quite recently, as we already learned, a French Court of Appeal overturned the first instance court's decision to dismiss a criminal case against French cement producing giant Lafarge, accused of being complicit in sustaining Islamic State by paying them tens of millions of dollars in order to continue production in the IS-occupied territory. While this may be a promising development for those, including myself, who are of the opinion that corporations should be held responsible for their involvement in international crimes, if possible, by means of criminal prosecution. However, it's only possible in states acknowledging corporate criminal responsibility. France has always been in the vanguard. Germany has always been adamant. And I've learned that Austrian legislation provides for corporate criminal liability since 2006. It still remains to be seen how the case will develop. Causal relationship, mens rea, are always quite difficult to prove, and corporate lawyers are trained to seduce the prosecutor's office to reach a settlement in order to spare their clients severe loss of reputation. Moreover, Al Jazeera has accused the French authorities of hypocrisy. They were perfectly aware of Lafarge's dubious activities. France has demonstrated its goodwill to prosecute Syrian war criminals from both sides. In 2018, French prosecutors issued international arrest warrants against Syrian supporters of the regime, including Ali Mamlouk, a former intelligence chief and senior advisor of President Assad. However, in 2019, Italy entirely ignored the extent arrest warrants by inviting Ali Mamlouk for an official visit. Some have questioned the dauntless French initiative, pointing at the disaster of obtaining custody over al-Bashir and claiming that personal immunities in the interstate context are still absolute. Look at the ICJ case of Belgium versus Congo. However, these arguments are flawed because Ali Mamluk is no longer in office and it is highly questionable if an intelligence chief can claim personal immunity in the first place, these prerogatives being reserved for government officials in the highest positions. It is much more likely that such endeavors are hampered or obstructed by political than by legal considerations. After all, the parties triumphant in the recent elections in Italy, Lega Norte and the Five Stars movement, have frequently expressed their admiration for Russia and Syria's fight against terrorism. It is too early to draw any conclusions from the efforts that have been undertaken against the culprits of atrocities that are connected to the Syrian government. We have only just begun, to quote the title of an easy listening song of the Carpenters that probably no one of the youngsters in the audience will know, but the older ones perhaps they do. However, I'm not too optimistic. Political expediency will probably gain the upper hand over moral scruples and legal principles. Even Anwar Er, a positive sign of the commitment to level the playing field and start criminal proceedings against current power holders, is a relatively easy catch. In order to substantiate my somewhat morose intuitions, I would like to contrast the scarce progress in prosecuting the representatives of official power with the fervor that has been exhibited in moving against members of IS and other non-state actors. To that purpose, I will discuss a number of fairly recent Dutch criminal cases dealing with suspects that stood trial on charges of membership, participation in a criminal organization. Now, participation in a terrorist organization, it will not surprise you, is a criminal offense in Holland, Article 140A of the Dutch Penal Code. When does one incur criminal responsibility? That's a good question. Borrowing from the provision on participation in a criminal organization, the Supreme Court has identified a number of elements. There must be a durable, steady, not short-lived collaboration within an organized structure, and the accused must belong to that organization. Secondly, the organization must have the intention to commit terrorist offenses. And thirdly, the accused must have made some contribution in furthering the organization's objective. Now, this final element is pretty vague because it can encompass almost anything, as was confirmed by the Dutch Supreme Court. So what counts as a contribution to a terrorist organization's objective? Recent case law has shed light on this requirement. In a very recent case, only of September this year, the accused was charged with participating in the terrorist organization of Jabhat al-Nusra. He was apparently one of the big shots of the organization, had close contact with other high-placed persons, and avowed that he thoroughly hated the regime of Assad. Well, he's a good companion, I guess. All right, but what did he actually do? The court emphasizes that he occupied a leadership position and added that such persons have a duty to restrain the conduct of the other combatants. There is no mentioning of any superior-subordinate relationship that sustains such obligation. Apparently, he has been present during the commission of violent acts by terrorist group. That would suffice for accepting aiding and abetting, provided that it could be qualified and interpreted as encouragement. Look at the Furungia case. Furthermore, he confessed that he had no problems watching movies footage that revealed the killing of military of the government of Assad. He was sentenced to 15 years and 9 months. Another case by the same district court of Rotterdam features a female accused who faced the same charges. The proof that was adduced to sustain the charges of participating in a terrorist organization included chats and Facebook pages on which he showed weapons and bomb belts. She clearly glorified the appalling violence committed by Islamic State, traveled to the battle area, and by taking care of her children and supporting her husband, basically doing husbandry by doing household work, she facilitated the intentions of Islamic State. Even further removed from actually committing violent acts or furthering those acts was the lady that stood trial on account of an attempt to participate in a terrorist organization. She had learned Arabic and had immersed herself in the ideology of Islamic State. In ardent farewell letters to her parents and family, full of religious fervor, she confided to them in telling that she wished to travel to Syria. However, she did not succeed in the mission and got stuck in the border between Turkey and Syria. She was convicted on the charges and sentenced to more than a year prison, a half year on probation. It is interesting to compare such rather inconspicuous contributions to another case in which the accused was acquitted for participation in a terrorist organization, although he had joined the organization Afrar al-Sham, a subsidiary of al-Nusra, that defended the village of the accused against the siege of Assad's army. While Afrar al-Sham was part of the Syrian Free Army that has been supported by the Dutch government, it had nonetheless been depicted as a terrorist organization that, according to the Dutch Supreme Court, deserved that qualification because it was bent on toppling and destroying the Assad regime. Yet accused activities as a civilian guard and member of Afrar al-Sham did not yield participation in a criminal organization. In this case, the organization derived its terrorist label from the fact that it aimed to fight the Assad regime. But he accused himself by merely defending himself against the Assad regime that suddenly was qualified as terrorist itself. So it's very interesting, the reversal of this tax. Did not harbor a terrorist motive. Was that relevant for the legal question? One is tempted to wonder whether the outcome was not influenced by the Dutch sympathy for the cause of the organization in question. Another judgment of the District Court of The Hague was rendered slightly later this year. In April 2021, the court obviously confirmed that Afrar al-Sham was a terrorist organization, but was confronted with a suspect that had engaged in specific activities that differed from the one of his fellow travelers standing trial before and being acquitted, as we recall. He had allegedly desecrated corpses of Syrian soldiers on the battlefield, and the court qualified this appalling behavior as inhuman and degrading treatment. The court noticed that the suspect had inquired about the ethnicity of the victims, and having learned that he was an Alawite, he continued with added vigor. From the fact pattern, the court deduced that the suspect was not only determined to defeat and topple the Syrian regime, but was also inspired by hatred of religious minorities. It next reached the conclusion that such motives could be attributed to the entire organization as well. The final case that I wish to briefly discuss concerned the relationship between war crimes and terrorism, because there is, of course, some overlap between them. The Court of Appeal in The Hague addressed the criminal responsibility of a 49-year-old Syrian warrior who was charged both with committing a war crime and participation in a terrorist organization. Mind you, there is this double point, yes, war crime and participation. The court convicted the suspect on the first count, as it found the man guilty of being involved in killing a captured officer of the Syrian army. That's definitely a war crime because the victim enjoyed protection as a POW under Common Article 3 of the Geneva Conventions. However, the court acquitted the man of the charge of participation in a terrorist organization. Interestingly, the court casted reliable doubt on whether the organization harbored a terrorist motive. It was engaged in a fight for life and death with the official Syrian army, and the act, though a war crime, was inspired by feelings of vengeance rather than pointing at terrorist intentions. Well, I just give you a bird's eye view of a couple of very recent Dutch court cases. They shed an interesting and sometimes a bit confusing, if not disconcerting, light on the interpretation of participation in a terrorist organization. I wish to raise some questions and make 3 observations. What is the relationship between the terrorist organization and the alleged participation of the members standing trial? More specifically, which one of the 2 should harbor the terrorist motive? From a purely methodological and analytical point of view, the approach of the District Court of Rotterdam was sound. It inquired whether Ahrar al-Sham could be qualified as a terrorist organization, a question that it answered in the affirmative. Next, it investigated whether the accused, by guarding the village in which Ahrar al-Sham had entrenched itself against the assault of the Syrian army, facilitated the terrorist objectives of the organization without paying much heed to the motives of the accused. The court decided that he did not. One could wonder whether that conclusion was correct, especially in view of the fact that much lesser contributions were previously found to yield participation. After all, did the defense of the village not assist the purpose to bring the Assad regime to heel? One may be inclined to wonder whether Dutch authorities, including courts, did not find such an objective less despicable than, for instance, Islamic State's apocalyptic fantasies. The Court of The Hague turned the issue on its head by scrutinizing the behavior of the accused. It deduced a wider terrorist motive from his actions, and they betrayed a discriminatory bias against a religious group, and attributed this motive to the entire organization. So it's exactly the mirror image. While this reasoning is legally less convincing, I have some sympathy for the court's approach because it recognizes the interaction of the organization and the members. Organizations, corporations, referring to the keynote of my friend and colleague Kai Ambos, act through their members. They have no soul or motives, only their members have such attributes. Moreover, the court remains closer to the pristine understanding of terrorism as a strategy to deliberately ignite fear in the civilian population. It's a topic that I will briefly address forthwith. Finally, the Court of Appeal of The Hague fully conflated the terrorist nature of the organization and the participation of the accused in that organization. It was a mess. While it's finding that war crimes and terrorism, although partially overlapping, have to be distinguished, it has merits, the court's analysis of the charge of participation in a terrorist organization is flawed. It held that it could not be excluded that the organization was not a terrorist one. The awkward double negative betrays the court's deep doubts, as it had just found that the organization intended to force the Syrian army to quit the region of Deir el-Zor, revealed the terrorist character. However, the court conveniently skipped the thorny issue by focusing on the accused participation, the killing of captured Syrian soldiers, and holding that this action was not inspired by a terrorist motive. It could not serve as evidence sustaining the finding that the entire organization was terrorist. Essentially, this approach mirrors the one followed by the Hague District Court, with the important difference that the appeal court denied the terrorist motive of the accused and used this to argue that the organization was not a terrorist one. It is one thing to deduce positively the terrorist nature of an organization from the attitude and actions of its members. It is quite another issue, however, to negatively conclude that the organization has no terrorist inclinations whatsoever on the basis of the finding that one or more of the action of its members was not committed with a terrorist motive. After all, that is not a legal element of the crime. It suffices that the accused facilitated their terrorist objectives without having to share such ideology. What should we make of all this? Although I find some of the elements of the cases briefly discussed deserving, the rather different outcomes and reasoning are quite disconcerting. Personally, I do not blame the Dutch courts so much for creating the confusion. They simply followed an authoritative definition of terrorism. The real problem resides on the international level, and that takes me to my second comment. The elusive concept of terrorist motive. Both the Convention on the Suppression of the Financing of Terrorism of 1999, which is in force, and the draft Comprehensive Convention Against International Terrorism define terrorism as a couple of violent acts committed with the purpose of either to intimidate a population or to compel a government or an institutional organization to do or to abstain from doing any act. Manuel Ventura has coined this rather resourceful adjective of a bifurcated approach. There are some differences between these conventions, the draft convention being far more disastrous in its potential scope. Well, we all hope that it will never be accepted, but I have a clear hope that it never will. These differences need not detain us here. What I wish to emphasize is the disjunctive or. It implies that a violent act against a government qualifies as terrorism. States have succeeded in squeezing in this condemnable expansion of terrorist motive, thereby distorting the original understanding of the concept. Terrorism and by extension, international crimes are not directed at official power holders. They choose civilians as their targets. They are committed by states or by non-state actors, the state being too weak or unable to protect its citizens. Obviously, states have a strong stake in disqualifying their adversaries as terrorists. They do so every day. But the perversion of the concept has troubled domestic courts in Holland and other countries and will continue to do so. The search for motives in either the accused or the organization they allegedly intend to facilitate, assist, and the confusion between the two is compounded by this unwarranted extension of the concept. If you qualify terrorist as an attack against the government, it is the death knell for the political exception in extradition law, to give just one example. My final comment is both reflective and critical. In my view, the attention of domestic jurisdictions for foreign terrorist fighters is disproportionate. The number of killings and casualties that can be attributed to the Syrian regime of Assad is far greater than those for which non-state actors, including International Islamic State, are to be blamed, although the latter are admittedly more spectacular. Remarkably, much more criminal cases in the Netherlands, and I assume also in other European countries, concern terrorist suspects. And again, of course, there is an overlap with war crimes in this specific case. There are a couple of practical and policy reasons for this discrepancy. What I did not mention until now is that most accused standing trial in the Netherlands on charge of terrorism have closer bonds with the Netherlands, either through nationality or residence. Jurisdiction is therefore not predicated on universality, but on so-called stronger principles. Moreover, their return and presence in the Netherlands yields an acute threat to society, so prosecutors and courts have an incentive to act quickly. A third reason, however, is often slightly pulled under the rug. It is politically far less sensitive and far more easy to enforce criminal law against non-state actors. One can be sure of cooperation of other states. Maybe they will applaud it, of course, and the risk of insulting states by probing into their secret sins is negligible. I do not wish to spoil the party on this beautiful Saturday morning, as I fully endorse the efforts of domestic jurisdictions to apply universal jurisdiction in order to also, and perhaps primarily, state officials that have engaged in international crimes. But I think that we must be candid in avowing that one faces an uphill struggle. I thank you for your attention.